Did you give them your bar number?
No, not yet.
They need it on the sign.
All right, well, I think we're going to get started. Welcome and good morning. My name is Sabra. I am the Director of Training Programs and Strategic Business Development here at the University of Dayton School of Law. And welcome, we're so thankful for you to be here today for this co-hosted government contracting workshop series, the first in our government contracting workshop series with Thompson Hine. And we're very pleased and thankful to have you here with us today. And just before we get started, briefly mention our government contracting and procurement master's degree and certificate programs here at the University of Dayton School of Law. We offer a master in the study of law in government contracting and procurement, as well as which is a 30-hour master's degree offered fully online. We teach to the federal acquisition regulation and the DFARS. And we also offer, along those lines, a 12 to 14-hour certificate program in government contracting and program project management. And the courses offered in those certificate programs are the same courses offered in the government contracting and procurement master in the study of law. So if you happen to take the certificate program courses and fall in love with the courses, you can then finish up with the master in the study of law. So if you have any questions about the program, I'd be happy to discuss with you. And again, welcome and thank you for being here.
Thanks a lot, Sabra. I will thank everyone again for attending in person as well as our virtual attendees. My name is Jamar King. I am a partner in Thompson Hine Dayton office. I'm in our business litigation and government contract practice groups. I have represented clients in litigation throughout the country in a wide range of industries, but I focus on representing government contractors with their issues, and that's everything from general commercial disputes, prime sub disputes, certified claims against the government. I've done some compliance work, and in particular, I've helped several of our government contractor clients respond to information requests and subpoenas and government investigations. I will be facilitating the presentation today. But I will be leading our next workshop series, which is all about navigating investigations and litigation and disputes. Andres and Jasmine are here with me. They are my colleagues from the Columbus office and our Washington, D.C. office. Jasmine is a managing associate in our corporate transaction securities group. Her multifaceted practice includes advising companies of all sizes, from startups and small businesses to large private companies, regarding entity structure, formation, governance, and financing, as well as business and commercial document preparation. She focuses on representing clients operating in the government procurement industry. Before practicing law, Jasmine was in the United States Army, where she held various military leadership roles, including platoon leader in the military police, executive officer, and a battalion plans officer. Jasmine is a combat veteran and a recipient of a Bronze Star. Andres is a member of our government contracts practice team. He is zooming in today from our DC office. He is a managing associate. He focuses on federal contracting and small business procurement, general corporate law, impacting government contractors. He has extensive experience advising startups and small businesses on entering and competing in the federal procurement industry. Before practicing law, Andres was a law clerk for the United States Small Business Administration, the U.S. Civilian Board of Contract Appeals, and the U.S. House of Representatives Committee on Oversight and Government Reform. This is a hybrid presentation, so there are people in the room here, and there are also several virtual attendees. The one thing I can guarantee is that there will be technology issues at some point, so please bear with us when those inevitably arise. And I have before we get started, I have a few housekeeping items that I must read, or the people running the show in the background are going to yell at me. So give me a minute to get through these. Number one, this program is being recorded. We will send a link to all of the attendees within 48 hours showing this presentation. This presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members and do not necessarily reflect the opinions of the panel members' clients, Thompson-Hine, or the University of Dayton. This is general information and should not be considered legal advice. For those attending virtually, if you have questions during the webinar, please use the chat feature and on the question box located in the control panel on the right side of your screen to submit your questions. I will do my best to make sure that your questions are addressed. And if your questions aren't addressed, we will make sure that if your questions aren't addressed during the presentation, we will make sure that we address them after the presentation. With respect to CLE credit, for those of you attending virtually, be sure to complete the verification of attendance survey. A link to the survey is included in the agenda that can be found in the handout section of the control panel located on the right side of your screen. We will also paste the link to that chat at the end. We also post a link in the chat at the end of the program. The tracking codes will be announced during the program. For those attending in person, please remember to sign in and out on the sign-up form right outside the door here. Additionally, for those attending virtually, also in the handout panel, you can download a copy of the PowerPoint slides as well as the bios of today's speakers. We will have, well, everyone in the room already has a copy of the PowerPoint slides as well as your Starbucks gift certificates. And if you did get one, please let me know. Again, thank you all for attending, and we hope that today is very informative and useful for each of your individual business endeavors. If you have any questions at any point for the virtual attendees, please place them in the chat. And for the in-person attendees, please raise your hand and we'll do our best to get to your questions. Okay. Jasmine?
I do believe Andres is going to start.
Andres,
Yeah.
Sorry.
Yeah, good morning, everybody, and thank you so much for that introduction, Sabra and Jamar. I'm glad this is being recorded because I'm going to have to work on my elevator speech based on that introduction. So thanks. So yeah, today we're going to go over a sort of government contracting 101, what you need to know to enter this unique, space and industry. There is a lot of ground to cover, and many of these slides and a few of the bullet points could be their own presentation. So, bear that in mind and know that, things go a lot deeper than what we're going to cover. But the four broad categories of what we're going to go over is basic overview of the federal government's acquisition process. Some strategic teaming insights for early success in entering the marketplace alongside experienced government contractors. We're going to talk about the small business certification programs at all levels of government, and then some common compliance issues for new contractors. So we'll get started with the overview of the acquisition process. Jamar, next slide, please. So the federal acquisition regulation is the main.
Give us 1 second. Here's the first technical issue. All right, I think we're ready.
Okay, great. So the main regulation is the federal acquisition regulations, and this is the set of regulations that operate to incorporate federal procurement statutes and provide for that. Sorry, are we having additional issues? Do I need to pause, or are we good?
I think we're good now. Okay.
Okay.
Sorry.
Okay. Thanks very much. Well, first let's start by wishing the FAR a happy birthday, 40th birthday actually. It was first came out in April 1st, 1984, so 40 years of the FAR. So this serves as the primary regulation for all executive agencies to ensure adherence to procurement statutes, but it does not actually apply to independent agencies such as the Postal Service, the FDIC, et cetera. To further sort of complicate things, there's 30 agency supplements to the federal acquisition regulations. The Department of Defense has the DFARS, which is usually the one you hear the most about beyond the FAR. But each of the branches of the military also have their own supplements, the AFARs for the Air Force, et cetera. And then most civilian agencies, or quite a few civilian agencies, have their own as well. So the EPA has the EPAR, and so there's quite a bit going on there. As with any set of regulations, the FAR is constantly changing via rulemakings. This includes the sort of rulemakings that we often see where agencies announce new regulations. But there are also sort of short-term deviations from the federal acquisition regulations that are issued either by specific agencies or government-wide deviations that are issued by the Office of Personnel Management and Budget, the Department of Defense's Contracting Secretariat, et cetera. So there's quite a bit going on there. And major changes are also often made through the annual National Defense Authorization Act, the NDAA. And this is often where Congress sort of deploys procurement policies and how they make major changes to the way that the government buys things, but also the way that government contractors conduct themselves. One of the things that I often tell clients is that the federal procurement space is often where the government tests out regulations that they wish they could do in the private sector. So there's a lot of unique sort of obligations on government contractors that you won't see in the commercial space. And then there's, of course, some, collision with some additional regulations from, other, sort of parts of the government, such as the Department of Labor. They have employment regulations that impact government contractors. The Small Business Administration has small business contracting regulations. And then there are some regulations from the State Department and Department of Commerce that have impacts on government contracting, and we'll touch on a few of these when we talk about compliance issues. Next slide.
Okay, Andres, we're still having some audio issues in the room here locally. We're going to try to resolve that quickly, but just give us a couple seconds, okay?
Okay, sure.
Okay.
Okay, great. Well, apologies for that. Getting back to the introduction here. So we're going to talk about some of the various acquisition methods that the government uses to buy goods and services from government contractors. So there's an initial process is called the sealed bidding process. This is governed by FAR Part 14. And this is the preferred acquisition method of the FAR in terms of at least how the regulations are set up. And so the regs require that the government issue a invitation for bid for sealed bidding. If time permits, an award can be made based on price and related factors, but largely on price. Where it's not necessary to conduct discussions with the bidders, which is to clarify, aspects of the bid, and that there's a reasonable expectation of receiving more than one bid. And this part of the FAR requires that the award be made to the responsible bidder, whose bid is responsive to the terms of the IFB and most advantageous to the government, considering price and price-related factors. And responsibility is a term of art here. That means not only capable of performing all the obligations under the contract, but also things like the contractor isn't prohibited from contracting with the government, say by way of a suspension or debarment, banning them from participating in procurement. Next slide, please. So it might surprise you based on that mandatory nature, but the sealed bidding is actually not the most common way that the government buys. It's actually the negotiated procurement governed by FAR Part 14. This is permitted when the contracting officer determines that there's an exception to the standard sealed bidding is warranted, and they have an enormous amount of discretion and authority in doing that. And frankly, in almost everything that we talk about, the contracting officer of the government has enormous discretion and authority. In this acquisition method, the agency can engage in those discussions I referenced before and can consider non-price factors such as experience, technical approach, past performance, and some of those factors that aren't directly related to price. So that this is the preferred method, likely because the government can consider things beyond price. So that's why it's preferred. So what this generally begins with is the issuance of a request for proposal, which outlines the specifications and instructions to the offerors and the evaluation criteria for the competition. And compliance with those specifications and details is very strictly enforced in both directions, right? So if a contractor doesn't strictly adhere to the proposal instructions, then their bid might be thrown out as non-responsive, and there's very little that a contractor can do in that circumstance if that determination was reasonable. Same thing with the deadline for bids. If you're literally a minute beyond the deadline, the government can completely disregard your bid, or if you're a page over the page limit, they can disregard that last page. So very, very strict. But it's also strict on the government side as well. If they don't strictly follow their solicitation and federal procurement regulations in conducting the evaluation, then the award can be overturned through a protest by a disappointed offeror, or before even proposals are submitted, a challenge to the solicitation terms can be made based on violations of procurement law. So there's definitely very strict compliance that's needed on both sides of this. And in terms of how the government evaluates, they can use the lowest price technically acceptable approach, which is, as it suggests, the lowest price that checks the minimum requirements of the solicitation. Or more commonly is the best value approach, which allows the government to award to not the lowest price, but the one that they view as the best value to the government, considering non-price factors. But they do have to engage in that evaluation process reasonably and make those sort of trade-off decisions that justify awarding to a more expensive offeror in a way that complies with both solicitation terms and procurement law. Next slide, please. So some other methods that I'm going to cover really high level are things like the other transaction authority. Now, this is specific to the Department of Defense, and these are for contracts with non-traditional defense contractors, which are generally just contractors who don't have a history of performing under government contracts or subcontracts with the Department of Defense. And these are usually used for research and development. Importantly, these are not subject to the federal acquisition regulations. OTAs sort of have their own unique authority. And the other sort of unique aspect of this is that the government gets to be a little bit more agile and controlling over the procurement process because of that. And they often, get the benefit of having some unique licensing and potentially ownership over technology that's developed through a OTA research and development contract. Next is the simplified acquisition procedures. This is through FAR Part 13, and they govern various types of acquisitions that are currently, the threshold is valued at less than $250,000. This allows for, as it suggests, a much more streamlined, simplified process that allows the government to be more nimble in making small acquisitions. And then finally, there's the sort of government-wide acquisition vehicles and multiple award sort of contracts, such as through the General Services Administration's Federal Supply Schedule. There's also agency-specific government-wide acquisition vehicles. I'm sorry, agency-specific acquisition vehicles and government-wide acquisition vehicles. These are effectively a fishing license. They allow for the government to vet contractors before they actually award them substantive work. The initial competition is just for that effectively license to pursue additional work in the future. And then there are task order competitions or straight, sole source awards to holders of those vehicles or indefinite delivery, indefinite quantity contract vehicles. So the task orders themselves are usually where much of the actual rubber meets the road with these procurements. Next slide. Okay, so in terms of contract types, I'm going to be pretty quick with this given some of the time that we've lost, but there are, broadly speaking, 4 different contract categories, and within them there's a few subcategories. First one is fixed price contracts, and this is supposed to be used when the entire performance scope is known at the time of bidding. Within some reason, there can be some changes during performance. But the idea is that there's enough known that the government can evaluate the cost and the technical approach proposed by the contractor at the outset. Now, the risk in this situation is really on the contractor if the price accepted is lower than the costs of performance. But on the other hand, the risk is on the government where the cost of performance is far lower than the accepted price. So that's the sort of allocation of risk that's agreed upon in that situation. And this can be paired with additional sort of hybrid types of contracts, such as firm fixed price level of effort, where a specific level of effort, usually measured by employee hours or some other objective measure, where if that level is met, the fixed price is then paid. And the next type is cost reimbursement. This is usually where there's a little bit less known about the total level of effort that's going to be expended at the outset of the contract. And what this does is it is the contractor essentially setting the price for all of its allowable expenses that can be allocated to the contract up to a certain limit, plus usually an amount for overhead and profit. This is generally lower risk for the government because they can they basically only pay for the actual effort expended, and the contractor does, though, gain some benefit if there are cost overruns that nobody expected. So that is something that to keep in mind there. This also can be mixed with a few other types, cost plus fixed fee, where there's a pre-negotiated fee when the contract is finalized, that's paid out, and then cost plus incentive, where there's an adjustable fee based on performance incentives. Then there's time and materials and labor hour. These are essentially very close to cost reimbursement, but they are certainly the highest risk to the government and the lowest risk to the contractor. Because the government reimburses all labor and expense costs with essentially no limit. Cost reimbursement is usually based on a fixed ceiling that can't be surpassed. This type is really only used where it's impossible to accurately estimate or anticipate the extent or duration of the work involved. So the government tends to disfavor these. And finally, there's incentive contracts. These are essentially cost reimbursement plus the incentive fees. But the incentive, that's the most common, but there also can be pure incentive contracts, which are largely sort of treated as almost commission-based contracts based on specific targets that the government must hit. Next slide, please.
If you don't mind me jumping in real quick, Andreas.
Sure.
As he was talking about, the contracts and their requirements, I do want to say, I heard from a contracting officer one time, he said, just answer the questions, right? As you're going through the contracting process, answer the questions, answer them fully. Don't try to infer what is being asked, because what is being asked is being asked. There's no rocket science to it. So, you answer the questions, you answer them fully. And usually the contracting officers, if you speak with them, they usually can't give you any additional information because there is no additional information. So that's just kind of a practice point with that one. What's on the paper is what's being asked.
We see tons of the small business investigational research contracts in this Dayton area. Any comments on how they fit in this picture?
Oh, that's a great question. On the state level?
Well, with regard to the various, apparently they're not a sealed bid, either they're cost plus or I just wondered whether there were comments regarding how that fits in the overall issue of government contracting. These are less than $250,000 at phase one, and that kind of thing. I just was soliciting additional thought.
Yeah, Andres, the question from the audience member here was about investigational research contracts and how that kind of fits into the conversation you just had there.
Yeah, sure. So those are governed in a sort of similar way to the OTAs that I mentioned, but to complicate things further, when we're talking about small business innovation research, SBIR or STTR, right? These are sort of an increasingly used process by which the government acquires sort of research and development technology from contractors, but it's a little bit unique in that these are sort of governed a little bit more like grants than they are like contracts. So it's much more of the government is funding a research project that may have may lead to a contract in the future if the technology does end up being something that's going to be useful for the government to acquire. And as part of that process, yeah, it's usually that the small businesses or the research entities are essentially given a grant to develop that technology, and the government is essentially getting a license to utilize and reproduce that technology with certain restrictions on what they can do with it. But largely, it's really, yeah, it's more of a grant approach rather than an acquisition. What often happens is when the SBIR grant contract leads to technology that the government sees a procurement need for, there'll be a separate follow-on procurement that will follow that.
We see a lot of the SBIR grants. Those are usually companies that are, again, exploring the technology, or startups that are trying to explore that technology in hopes of some sort of procurement. I would say they are, from the startup world, pre-seed, seed type funding, and they usually come in tranches. You have to prove, moving from one tranche to another, that there's some sort of movement on that research.
Well, thank you. Good question. Okay, so we're now moving on to what teaming looks like in the federal marketplace, and this is a good entry point for small businesses. What I advise a lot of government contractor startups is you can have the best products, you can have the best team, but you really need mentorship in this space. This is the type of environment that is very difficult to figure out from the ground up, and to access the marketplace without somebody who's already got some access. So teaming is certainly huge. And the way that the FAR sort of defines the contractor teaming arrangement is basically it's two options. There's a partnership or joint venture between two or more companies that collectively basically own an entity that itself pursues a potential prime contract opportunity. And then the other is the more common one that most folks know is prime and subcontractor arrangements, where you've got a prime contractor who's agreeing with one or more other companies to have them act as subcontractors to perform some portion of the scope of work under a government program or acquisition. Next slide. So we'll start with talking about joint ventures. So as I mentioned, this is a separate business entity that's owned and operated by 2 or more contractors. Most commonly it's 2, and they jointly pursue the contract opportunity through that joint venture entity. So when the contract is awarded, it's not awarded directly to the contractors, but instead to that joint venture entity that the contractors own. The goal here is for that joint venture to be awarded, and as I mentioned before, right, the JV partners actually don't have a direct contractual relationship with the customer. It all flows through that JV entity. And the common approaches to this are between 2 small businesses, a small and large business, and a mentor-protege through the Small Business Administration's mentor-protege program. The reason why that's often used as a joint venture approach is because the Small Business Administration allows for a large business mentor and a small business protege to form a joint venture, and the joint venture entity actually gets to make use of the small business protege's socioeconomic status. We'll talk through some of the socioeconomic programs in a minute, but it allows them to gain access to contracts that are set aside for small businesses or women-owned small businesses, veteran-owned small businesses, et cetera. So the benefits to a joint venture process as compared to the prime sub relationship is that the joint venture's partners resources and capabilities, their past performance, some of the things that work their way into what the government looks at in evaluating are combined, right? So that enhances their competitive standing in a manner that wouldn't be the case if they were pursuing it on their own, or often, even if they were pursuing it as a prime sub. So there's an ability for the partners to leverage one another's experience, but also their market share and customer relationships. And as I mentioned, access to opportunities that are set aside for small businesses as long as the joint venture agreement and the relationship itself meets the Small Business Administration's standards for rendering the joint venture as a small business entity. Now, the risks of this process or this approach is that there is joint responsibility for performance, right? In a prime sub relationship, yes, the prime is responsible for the entire contract performance, but a subcontractor is really only bound by what they agree to in their subcontract with the prime contractor, and perhaps some other regulations and stuff that might be read into their subcontract. But it's a much narrower risk. So in the joint venture context, the additional issue is that there is dependence on your partner. So if it's not a good relationship, this can get a lot messier than it can be in a prime sub relationship, where maybe you cut the ties with the subcontractor or vice versa, and deal with the fallout in that way. This you're sort of tied together for the purposes of that contract. There's also the potential risk of customer confusion. We see this a lot, where the government gets a little bit confused about who's authorized to bind the joint venture. Even in a circumstance where you've got a small business, protege that has to have greater control over the joint venture to satisfy the SBA's regulations, the large business mentor might communicate directly with the government and bind the joint venture to something that the lead SBA protege wouldn't want to be bound to, and the customer doesn't really know the difference. So there's certainly that issue. And then the last issue is if you're a large business or a mentor that is a member to the joint venture, you often have to give up quite a bit of control and over the joint venture entity to that protege. So it's really important to get the relationship right there. Next slide. All right, I won't spend as much time on prime sub because this is a little bit more common, but it's an attractive option for partners that don't necessarily want to co-manage a jointly owned entity. So the main sort of issue here is that the government does not have a direct contractual relationship with the subcontractor, only with the prime. So that lack of privity is what we call it. It can lead to the subcontractor certainly having less control over things and being at a little bit of the mercy of the prime contractor in terms of performance and in dealing with issues with the government. So this method still does, enhance the ability to meet solicitation requirements where neither party can meet it on their own, but it's not quite to the level of a joint venture where it truly is combined. That said, some solicitations will allow for considering the technical experience and and merits of the subcontractor as part of evaluating the team if they're considered a major subcontractor, and that will depend largely on the solicitation terms. Next slide, please. So this begs the question, and we get this one not as much as we'd like. But are you already a subcontractor? It's amazing, and it might shock you that a lot of companies are actually subcontractors without even realizing it. The FAR purposefully probably does not define a subcontractor, and importantly, that status definitely does not require being a party to a quote-unquote subcontract. Unfortunately, there really isn't a bright line rule here, but the common approach is that if the company is providing goods and services that are identified in the prime contractor's scope of work, or the goods and services it delivers to the prime are a direct expense that are passed on to the government, generally that company is a subcontractor, at least as far as the FAR and the government is going to be concerned. So often we'll have clients who will be a little bit surprised to find out that their services are being provided, in this manner, and may be subject to additional regulations that go beyond the scope of what's in their agreement with their customer. So it's a really, really key thing to do, as anybody who knows that one of their customers is a federal government contractor, to really dig in to understand exactly what's being done with the goods and services that are being provided, to make sure that if you are a subcontractor, you know it, and can either terminate that relationship if that's what you want to do, or come into compliance with some of the stuff that we're discussing today. Next slide. So the reason this is important, as I said, is what is the additional stuff that I'm subject to as a subcontractor, right? So most typically we see this in the flow downs, and what these are the regulations and contract clauses from the prime contract that flow into the subcontract. Now, the way that they are supposed to be done is through your agreement. The agreement usually will list a list of flow downs that will say these are the clauses from the prime contract that come into the subcontract. Now, many prime contractors use we call it the kitchen sink approach, and simply just flow down all the FAR clauses from the prime contract into the subcontract, or in some cases even just attach the prime contract itself to the subcontract and say this entire thing is incorporated. Now, this is actually risky for both parties. Some of these FAR clauses are really not meant to govern subcontracts or subcontractors, and so there can be some contract interpretation issues that come along with that, and that can really work some havoc in both directions. Not to mention subcontractors just not fully understanding what they're agreeing to as part of these flow downs, many of which have it's really sort of hard to translate into how does this work for a subcontractor. Increasingly, the government's getting a little bit more aggressive about this kitchen sink approach. In fact, the Department of Defense recently prohibited flowing down FAR and DFARS clauses to commercial items subcontractors. So these are subcontractors that are doing sort of off the shelf stuff that they sell in the commercial marketplace that is being incorporated into a government contract. And in those circumstances, the Department of Defense says that you can't just flow down everything into that commercial items subcontract. So we'll see, how the enforcement goes with that, but that is something that the government is looking at. And importantly here, subcontractors, as I mentioned, don't have a direct contractual relationship. They don't have privity with the government. So because of this, if a subcontractor is harmed by an action of the government, they often will need the consent or cooperation of the prime contractor to actually press their claim. The subcontractor can't make that claim themselves. The prime contractor will have to do it. So this makes it really important to negotiate as a subcontractor with the prime to make sure that the clauses in the subcontract or other agreement provide for a mechanism by which the prime contractor is obligated to sponsor that claim within reason, and make sure that the subcontractor can be whole.
Well, I have a question.
Wait, we have a question, Grace.
So I guess I'm confused by that statement. If you're harmed by the government, but you have privity with aren't you being just harmed by the prime?
Well, it's possible. So, what will often happen.
Harmed by the government, if you don't have privity with the government, wouldn't that be through the prime contractor?
Well,
Wouldn't it be harmed by the prime contractor to the subcontractor?
In effect, yes, though what will often happen is the government may be in direct interaction with the subcontractor as to their portion of the work, and they may say something to the subcontractor to say, you need to change your work in some way, and you must do that. And you're absolutely right that in order to actually effectuate that order, that has to go through the prime contractor, and the prime contractor has the obligation, generally to object to that or to say, okay, we'll do that, but if we're going to do so, the government needs to, provide us with additional money, additional time, et cetera, right? But the government often can take an action that will directly impact the subcontractor. And sometimes the prime contractor will kind of take a step back and say, hey, look, I'm not going to do anything about this. Just you do what the government, says, and we'll deal with it. Well, that may be the case, but if that's going to lead to the subcontractor incurring additional costs that they didn't anticipate and didn't price their subcontract on, they should be able to be to be protected from that situation. And in that circumstance, you're right, it's the prime's obligation and their failure of that obligation in not making that claim. But that's exactly what the subcontract or other agreement is there to protect against, is to ensure that the prime contractor does their job, because otherwise the prime contractor might just say, well, we don't care if it costs you more, do what the government says, right? So in that circumstance, it then becomes, yes, a dispute between the subcontractor and the prime contractor. But if the government is going to, if it's a harm caused by the government, it's really up to the prime to assert those rights as to the government. Does that make sense?
Yeah, I just don't, if basically what you're talking about is a prime abrogating, stepping away from his contract. And so if that's the case, how likely is he going to give the subcontractor the permission to deal directly with the government? I suspect that the contract between the prime and the subcontractor have some kind of language that prohibits direct communication with the government. I've never seen those contracts, because typically my experiences with the federal government, we were typically not shared those contracts, those subcontracts with the prime. But I suspect they have some language that prohibits them from reaching out directly with the government. Is that true?
Yes, that typically is the case, and you're absolutely right that in those circumstances, yes, a subcontractor often can't actually go directly to the government to press these claims. And in fact, as I mentioned, right, without this privity, there's really no ability for the government to do anything specific to the contractor. This all has to flow through the prime contractor. But that's the reason why it's very important beyond, you know, some of those clauses that, you know, restrict communications with the government. What the subcontractor really needs is to make sure that the prime contractor won't abdicate their responsibility to pursue that claim. I'll give you a prime example of this sort of thing. I dealt with a contractor a few years ago that the prime contractor was having all types of issues on the job, and the government was really not happy with them. But our client, the subcontractor, was doing a great job. The government was very happy with them, but the government made a change that made it more expensive for our client, the subcontractor, to perform. The subcontractor then went to the prime and said, this change is going to cost us more money. We need you to, you know, to submit a claim. And the prime contractor said, we can't. The government is really mad about how much cost overruns we have over here, right? That we're not going to do it. And that ended up being a prime sub dispute where in that case, the subcontract did require the prime contractor to press that claim, and they refused due to their own issues, right? So this is the type of thing where the subcontract needs to be negotiated to make sure that the prime doesn't, you know, abdicate that responsibility to press that claim, because absent that language in the subcontractor may not have much recourse. Sure. Okay, we can go to the next slide. Okay, so now we're going to talk about small business certification programs, and I'm going to hand it over to Jasmine.
Thanks, Andreas. So Andreas talked about a couple different things: the SBA Mentor Protege Project, joint ventures. Small business certification programs are ways that small businesses can access some of those programs with the Small Business Administration. And we're going to talk about not just the federal ones, but we'll also dive briefly into the state level programs, so we understand the basic construction of those, and also some of the available programs on the private end. As you can see, agencies at all levels of the government are incentivized to provide these contracting opportunities for small businesses. Usually these businesses are diverse businesses, socially disadvantaged, economically disadvantaged businesses. For example, according to the SBA in fiscal year 2022, $163 billion were awarded to small business prime contractors and $79 billion to small business subcontractors. That is a lot of money. And here in the state of Ohio, fiscal year 2023, $350 million to MBE certified companies. This is a wonderful program for those businesses, small businesses that are eligible to access these types of contracts. So these types of opportunities present themselves as set-asides. They can be competitive. So usually those government-wide acquisition contracts that were mentioned prior, those tend to be, if they're under $150,000, those tend to be set aside for these certified small businesses or sole source. So that means only a single business can fulfill that particular contract. They may also be joint ventures. So Andreas talked about joint ventures. One thing that he mentioned was, having those joint ventures where one business may be a small business certified business. You want to make sure that that member meets that small business requirement and that there is a maintenance of their eligibility according to that particular contract. That means you can't have one of the joint venture partners come in, that may be the larger business, come in and completely destroy that small business eligibility for the smaller business. So that may mean that the smaller business is the one, the small business is the one that is either providing the actual goods or services. They have the ability to make sure that the business does not shut down without some sort of agreement or other things dependent upon that particular contract. It also provides training and technical assistance from the SBA. The wonderful thing about all of the small business certifications, diverse certifications we're going to talk about, is there's also some sort of training and other resources being provided to the businesses. It's not just, hey, you won the contract, high five, and you move along. there's other opportunities that are being provided. Specifically, the SBA provides that mentor protege program for those joint venture projects, in addition to other programs as well. Next slide, please. We're going to talk about some common requirements, and these requirements, they also flow down into state level and the private sector level certification programs as well, because the program, once it's established by the government, let's be honest, we all just kind of flow off of that, and it makes sense. So first and foremost, making sure that the business, it meets a small business status. Now this can vary. It's determined by average receipts and the number of employees or industry based off of your, I always say this wrong, NAICS code. So you could be a small business and you could have up to $350 million that you could have based off of your receipts, or you could have a certain number of employees, up to 50 employees for your particular business, to then be considered a small business. Ownership and control. And I always harp on this one because for some strange reason, this is the hardest one for folks to maintain, to achieve, first of all, to achieve, and then first of all, to maintain. 51% owned and controlled. So if there is a requirement that the program be maintained by be a woman-owned business, a minority-owned business, a veteran-owned business, that means you must have 51% of the equity, and there's also control as part of this. And we'll talk a little bit about control in the ways that people can't maintain their certifications. Socially disadvantaged or a minority status. So these are usually individuals that are subjected to bias in American society, historically subjected to bias in American society due to their identity as members of a certain group. So that could be ethnicity, that could be racial background, that could be based off of their location in the actual United States. And then economic disadvantage status. That also depends on, it's dependent upon the certifying authority of what is considered economic disadvantage, and we'll talk about that in each of the programs. But generally, it's based off of your income, your net worth, or any other financial status of a disadvantaged owner. And usually social disadvantage and economic disadvantage, they may play off of each other. Next slide, please.
Can I ask a question?
Yes, please.
So the control issue, I get what you're saying that.
Yeah.
So when you have certain things that are like in an investor who wants supermajority, where you have to have 100% board approval.
Yeah.
Where do you start walking into where that's not control, like in your experience? I know it's different probably with each contract, but do you have any general guidelines on where you start to cross that line of like, yeah, you like, I call it budget, business expansion, where do you start to run into issues on control where you don't have control because a minority investor is negotiating supermajority rights?
Yes. Anytime there's supermajority rights where a minority investor is controlling anything that you do, there's a concern. More often than not, we see it, especially in smaller businesses, where when someone has the ability to direct what the business is doing, not just on a daily basis, but whether they continue to exist. For most folks, it makes sense, right? All of your members should agree whether you dissolve or not. But if they change the lines of business, if they are directing who is on the board, that's some control as well, because they tend to put their folks on the board that will vote in their favor. So then they begin to have some control issues there, and it moves that control further and further away from that 51% eligible owner.
Yeah, if I could add to that, Jasmine.
Yeah.
So this is actually an area where the Small Business Administration's Office of Hearings and Appeals is starting to deal with this increasingly. And for the federal programs, what they've basically come to the conclusion of is that there are certain really sort of almost existential sort of decisions that that can be influenced by minority partners without running into a control issue. So, certainly the things that Jasmine mentioned, but also things like declaring bankruptcy in terms of adding, additional, members and diluting equity Those are really the sort of like high level sort of corporate things that, that can be influenced by minority members or owners. But once you get beyond sort of the real like corporate structure, sort of questions and decisions, that's when you start running into control issues. And I would love to tell you that there's a bright line rule. There is none. There never will be. And this is a constantly sort of changing analysis. But largely the way that we counsel clients is to say, look, if this isn't the type of thing that would be a sort of complete monumental change of the entire business structure or line of business, it generally needs to be in the control of that minority or disadvantaged individual that is giving you the eligibility for that program.
And like Andrea said, it's not bright line, and it requires a little bit of analysis based off of the circumstances as well. How you apply control to a limited liability company is different in the way that you apply control to a corporation, and how you apply it to an ESOP. I'm knee deep in reviewing an ESOP, and that is completely different from something that is held in a different manner.
So who can challenge that? Can another contractor challenge an awardee's status, say, where I've seen it, where they claim a woman-owned business, and basically the husband's doing everything, and then if he needs the wife to sign it, she signs it, but she really doesn't know what's going on with the business. He's running the day-to-day operations, but he needs her to sign typical documents so that they can keep the status. And then you hear, then there's a challenge that that's an improper. So who can challenge that? I mean, if the government is satisfied with that certification, and a lot of these are self-certified, aren't they?
No.
Okay.
Yes. So the SBA has changed their programs over the last, I would say, 5 years. So that self-certification is not available anymore.
So the Small Business Administration would withdraw that. So you would go to them for the challenge, I guess?
But, I'll let Andre speak to this, but a lot of times it's getting all further college into a bid protest. But with respect to the certifications, Andres and I are dealing with a issue like that right now, where the question was what regs were in place at the time the certification happened. Is it a self-certification requirement, or do you have to go through the process with the SBA? But Andres, I see you shaking your head.
Yeah, and that's right. I mean, there's really essentially sort of three different folks that can challenge. You're absolutely right, a protester, right? Two companies that are bidding on, say, we've got 8A up there, and 8A set aside, right? And the disappointed offeror says, you know what? I don't think that this company qualifies as an 8A. They can file a protest with the Small Business Administration. It's called a size protest. And the Small Business Administration will investigate that. They will request a whole bunch of information from the awardee to determine, do they satisfy all the requirements for the 8A business development program, whether it's control or the issues, whether the owner is economically disadvantaged. All of those sorts of things come into play. There's also additional issues such as affiliation, which is a complex issue, but basically if another company can control the awardee for the purposes of determining their size, they're combined. So yes, it can go through the contract specific size protest process. It also can be, initiated by the SBA. Most of these programs have regular recertification processes where the company has to submit information annually or sometimes every 3 years, and SBA looks at that and determines, do they continue to be eligible? And if they're not, then they'll kick them out of the program. And then another way that we're increasingly starting to see is by the Department of Justice. So one, the sort of example that you raised with the sort of, potential of a sort of figurehead owner who isn't really running the business, but is just kind of there to get that certification status. DOJ is trying to crack down on that. They are trying to identify those sorts of companies and say, you don't really qualify for this program. You don't, and you're doing all these things to sort of circumvent the regulations. That's, a really big deal to the Department of Justice, and they would, in many circumstances say that that's a violation of, say, the False Claims Act, which is a very serious statute that goes after contractors for procurement fraud. So that is another avenue that looks at this as well. But the most typical is the one that you cited, the size protest process.
Excellent. I will say one thing that wasn't mentioned, so once a small business falls outside of the certification, they have a time limit, usually 30 days, to report that from the time that they are officially outside of that size limit. So, or if they no longer meet those certification requirements. And then if they do not, you're opening up the can of worms of a protest, false claims. So these programs are fairly strict, and because they've intentionally transitioned these programs away from self-certification to avoid a lot of the problems that we see of businesses creating figureheads. I've dealt a lot where the husband is doing a lot of the work, but the wife is just the 51% owner, but doesn't have that control, right? So moving the certification programs away from self-certification to an actual review process. It's a bit more onerous on the businesses, because you need to make sure that you are providing all of your documentation, and that can be a fantastic feat, depending on how much documentation that particular business has or doesn't have. But it also provides them with less of an issue on the back end of having these big protests and folks being outside of the certification program requirements.
So what's the problem with don't certify too early?
Well, we're going to get there.
Oh, sorry.
Before we get there, I have one more note just about the False Claims Act. It's slightly outside the scope of this particular workshop, but Andres mentioned that the DOJ would come poking around and trying to figure out what's going on. But even if the DOJ decides that it wants to pass on it, the whistleblower could still pursue. Sometimes, there's kind of conflicting case law and Supreme Court decisions that recently affected that. But a whistleblower could try to pursue a False Claims Act even if the DOJ decides it doesn't want to intervene. So that's something to be thinking about.
Would that be under a qui-tam?
Qui-tam, correct.
All right, so we're going to talk about the 8A Business Development Program. So this is, I would say, probably the largest. I'd say, Andres, one of the largest federal certification programs that you have access to. So meeting this small business status, economic or social disadvantage. So previously there was a presumption of social disadvantage if you were a member of a particular racial or ethnic category. That has since changed due to recent Supreme Court decisions. There is no presumption anymore for this program, and we will talk about other programs where there is still a presumption. So, me, by nature of just being an African-American woman, I do not have a presumption of having a social disadvantage for this program. I would then have to submit a narrative that would establish that there is some sort of social disadvantage in my past that has disallowed me to be able to, or that has allowed me to qualify in this aspect. The economic disadvantage for this particular program, it's another thing that is dependent program to program. Less than $400,000 in 3-year average gross income, $850,000 net worth, and $6.5 million in total assets. You also must show a potential for success. So it's a lot harder for a brand new business as opposed to an established business to show that potential for success. Not always, but a little bit harder. And you must have good character. So that means you haven't been in trouble, your business isn't in trouble, there's no prohibitions for you moving forward with your business and with contracting with the government.
So what kind of evidence are you submitting on that good character?
You are making certifications that you have not. So a lot of this is submitted online. So you're making certifications I have not. Here's my good standing, my certificate of good standing with the state that I am registered in. So for the state of Ohio, you're submitting your good standing certificate that says I've paid all my taxes and I've maintained my certification or I've maintained my registration. If there are other certifications you've shown that you have not, so if you have state level certifications, you can also submit those to say, hey, I'm state level certified. I continue to be certified here, so I don't have any issues.
For Better Business stuff?
I have not seen Better Business Bureau. Have you, Andreas? No,
it's typically this good character really comes down to sort of really like high level, sort of issues like you haven't, you're at the taxes issue that has been mentioned, but also, you haven't been convicted of fraud. There's I mentioned briefly before suspension and debarment. That's the process by which a contractor or principals of the contractor, owners or employees are banned from contracting with the government, right? You haven't been suspended or debarred. Right, it's really that sort of stuff, and as Jasmine mentioned, yeah, it largely is based on certifications, but some of that stuff can be double checked by the SBA by looking at public records and filings.
it's more what you don't have to submit as opposed to what you do submit.
Warm breathing and no recent felony convictions.
Yeah, if you don't have felonies,
Which is
you're
probably a high bar there, or a low bar.
Now you asked specifically about the 9-year program. So this is one of the programs where there's an expectation of only being certified in the program for 9 years. There are other programs we'll talk about on the state level that have a similar certification when it focuses on your economic disadvantage. It's expected that being in this program will help elevate your business from small to large. So there's only a 9-year certification window for you to be on this program. So
if I can add to that real quick, Jasmine, specific to this program, the idea is that early in your tenure in this program, you're going to be dependent on a lot of 8A contracts and a lot of 8A set-asides and sole source contracts. And then as you progress and you get to be a little bit more sophisticated in terms of being a government contractor, you're gonna be less reliant on that. So this program is broken up into 3 sort of subcategories within that 9-year program, where at the early stages, you can do 100% of your revenue from 8A contracts. As you get towards the middle of the program, SBA actually wants you to demonstrate how you have a plan to be less reliant on 8A contracts. And then towards the end, be almost not reliant at all. The idea here is that early on in the 8A program, when it was first being utilized, what we saw is there was a lot of companies that did really poorly when they exited the program. And so the government is trying to avoid that by sort of enforcing this process by which you get less reliant as you go along. But what we see here a lot of times is that contractors say, well, I'm eligible, I should just go get certified. And they might do that, a year into their operations and before they're really ready, right? So then they might start getting a lot of their 8A contracts, say year 3 or 4 or 5 into the program, at which point SBA wants them to be increasingly less reliant on them. So that's why we say it's very important to make sure that you time your certification in this program well.
don't certify to earn. Thanks, Andreas. Next slide, please. Awesome, thank you. So the next program we're going to discuss is the Women-Owned Small Business or Economically Disadvantaged Women-Owned Small Business Status, Women-Owned and Controlled. This is one that we often see an issue where the ownership is there and the control is not, especially amongst, for some strange reason, husband and wife teams. And so, ensuring that that is true, that there is control on on that side of it, one way that a lot of certification programs view the control is also, does the woman or women who own the business, do they also have a relevant background? And we'll talk a little bit about that in certain programs as well. And that's a question that pops up is, do you have a relevant background in what you're doing? So they will ask to see a resume. You will be submitting a resume for, for the women-owned business, so that you can show, yes, I not only own this business, but I also have relevant experience in this particular industry as well. Economic disadvantage, so those are the same requirements as the AA, as you're showing the economic disadvantage. This particular program, it recently transitioned from a self-certified to a the SBA certification program, and WeBank, Women Business Enterprise National Council, is also a certifying authority for the economically disadvantaged women business, the WOSB. So it has transitioned out of the self-certification, mainly because there are issues with control, and they were seeing a lot of programs that have issues with that control. Next slide, please. Another program that has recently transitioned from, in this instance, the VA to the SBA is the veteran-owned small business and service-disabled veteran-owned small business. So you must show small business status, again, and that's dependent upon your industry, that your business is veteran-owned and controlled. If you are service-disabled veteran, that must be provided by the VA. So you can't self-certify that you are service-disabled veteran. You must have a rating with the VA that backs that claim, and you will be submitting paperwork to back up that claim, to support that. Now, the difference between the VOSB and the SDVOSB is not just service disabled. VOSB set-asides are usually with the VA only. So the VA wants to do business with SDVOSBs and VOSBs. SDVOSBs, so the service disabled, they have set-asides across all of the government contract, all the federal government contracting. So veteran-owned small businesses, that's a very, very narrow group of contracts that they have availability to on the federal level. Of course, if you're moving into state contracts, depending on the state, they may not have a state level veteran-owned contracting, Ohio being one of them for the time being. So they may accept the federal level contract, a federal level program and that certification in order to contract with the government for those particular veteran-owned business set-asides. Another great thing about this is, for service-disabled veterans, it's understandable that that particular disability may prevent you from being able to run your business. So there's an ability for a spouse or primary caregiver to manage that particular business for the veteran should they become incapacitated due to their service-related disability. HubZone, and this is a certification program that a lot of folks are definitely trying to take advantage of. So historically underutilized business zones, HubZones. It's intended to increase the contracting in a lot of these economically depressed, disaster area, or historically underutilized business zones. These hub zones are designated by the government and as these economically depressed areas. You must meet the small business status. But as you look at it, there's no ownership and control, right? There's no concern about whether you are owned or controlled by a certain economically or socially disadvantaged group. But your principal office must be located in that one of those hub zones that is designated by the government, and 35% of your employees must reside in a hub zone. That's difficult, right? Especially if you have a high turnover business, you may or may not have employees that reside in that hub zone, and hub zones tend to change. They may shrink depending on the economic area that you are in. I know I live in rural Ohio. Our hub zones have changed based off of some of the economic development that has happened without Washington Courthouse. So, we've got the Honda factory coming out there, and, that has shifted some of our hub zones slightly. Department of Transportation. So the DBE, SBE, Disadvantaged Business and Small Business Enterprise, focuses on federally assisted highway, transit, airport, highway safety, and other transportation projects that are happening on the federal side, but also on the state and local government as well. So you will constantly hear, state level Department of Transportation asking for the DOT federal DE or SBE program certification for their projects. The small business status, social disadvantage. This is not a program that is similar to the AA where they don't have that presumption anymore. This is a program that is still presumptive. Will that remain? We shall see. We're kind of in a hold pattern for a lot of these projects or a lot of these programs on whether they will be challenged or not. But as of right now, this particular program, it is presumptive based off the membership in a disadvantaged group. Economic disadvantage is different from the AA program. So less than 1.32 million of personal net worth of the particular owners. And a note for personal net worth, they will look at, if they are husband and wife team, they will look at their full net worth. They will not look at each of your net worth separately. They will combine that net worth together. And DBE certification assists with reciprocity in many states, as I mentioned. So if you are seeking a contract with the Ohio Department of Transportation, they will look for this certification program. Having the DOT certification program and using it in one state will also assist. You can't use the same certification. You will most likely have to be certified by that particular state's Department of Transportation, but having an award in one state is helpful when you are seeking award in an additional state for these particular contracts. All right, let's talk about state and municipal certification. Any questions on federal level certification? All right. And we're going to talk briefly about state and municipal. I know this is a program that is focused on federal contracting, but again, these certification programs tend to work hand in hand. You can have more than one certification, and that is usually part of the strategy that folks have for their contracting, not just with federal government, but with the state and municipal levels as well. So unfortunately, programs vary by state by state. And reciprocity from state to state may be fantastic, or it may be horrible. For example, the state of Ohio doesn't have good reciprocity with other states. Indiana refuses to certify any Ohio-based or Ohio certified company. You have to be based in Indiana, or you can have you may have an award, a certification award, so either MBE or WBE from a very narrow number of states, but Ohio is not one of them. They have similar elements to the federal programs, the ownership and control, and social and or economic disadvantage. And of course, that varies program to program. These usually are not self-certified programs. And an issue that pops up is there are programs that hold themselves out to be state level programs, but they're really privately run. The state of Texas is one of those. I had a client that submitted and paid a fee to a program that was, it was holding itself out to be the state of Texas providing certification, and then they were waiting months and months and months. And they never provided certification because it wasn't a real program, they got scammed. So making sure that you understand each of the state's programs and that is actually something run by usually either it's a separate Department of Development for the state of Ohio, that is the that is the department that runs for the state of Ohio, or they may have their own separate, diverse business certification group or department within those states. So that's a note. The states may also have additional requirements. Residency may be one of them. The state of Ohio is one of those. Indiana is another one. You have to be a resident in the state, or you may have to have a certification in your particular home state in order to then apply in that state for certification. And often on state level programs, time and operation. Now, we didn't talk about time and operation on the federal side. There is no requirement there. But usually on the state and municipal levels, there's a requirement of being in operation for at least a year. That's usually to certify that you are in business. This is not just a shell company. This is not a business that is put in place for no reason whatsoever, that this is an actual operating company. And on-site visits. So someone from the Department of Development for the state of Ohio will come out to your business and they will ask you questions about your business to ensure that you are actually in operation and you actually know what is happening in your business. And if you are holding yourself out to be the owner and in control of the business, they will ask questions to ensure and support that.
So how is that residency in the state defined? You have to, you're paying taxes in the state, this is your home or your
Yes, usually
primary operation?
home of residency. Yeah, home of residency, so you have an actual address.
But if you have a business that crosses state lines, say you're on the, you operate some business or some work in Indiana.
Yeah. It's your residence as the owner.
Okay.
There are some folks who they may have multiple headquarters, and that has been a workaround for some folks and it's not recommended, where they have had an owner, so one owner is in Indiana, one owner is in Ohio, and they operate the business out of the Indiana owner's address. Again, not recommended, but that has been a workaround that we've seen for that particular residency in that case. Again, the reciprocity varies across the states. A lot of what I do for clients when it comes to state certification is look at where they do have reciprocity and where it makes sense for them if they are an Ohio company or a company operating out of a different state. Where is it easier for them if they're operating in that state for certification?
So related to this, I've never been able to figure this out because my business is registered and set up in Washington State.
Yeah.
And my business partner and I were 50-50 owners, and she's in California. She was in Washington, moved to California, but we kept our business registered there. And I'm here in Ohio, and we're both 50-50 owners, and we've got staff and
A bunch of other places.
so we never know which states were eligible or how that would even work out or when.
Right.
So we've never been able to really dig in. So what would you recommend? Which states were you look?
So usually when that problem arises, and that is great because it brings me to my next slide. So when that arises, I usually talk about private sector programs. And those are programs like WeBank, Novoba, NBC, and MSDC, where these are programs that are privately run. So they are private nonprofits, coincidentally, that certify eligible businesses that usually work with Fortune 5, larger private sector clients. They may be public businesses as well, but they are usually not the government. They are usually your Fortune 500 companies that are looking for those subcontractors, those folks that can come in and provide them with services. They may be eligible for their tier 2 program, tier 2 supplier programs. And this is something that applies across the states. And a lot of states will also look at if you have a WeBank or Novoba, they will look at those programs and say, okay, this makes sense. We will either fast track, or, this helps grease the skids for your particular situation. So I usually recommend that if you have folks that are in multiple states, if you're doing business in multiple states, and especially if you are working with private sector companies, larger companies that, they really look favorably on these particular certifications. It prevents you from having to seek all of the certifications statewide, but also I always urge folks to look at, the state contracts, the state requirements, just as you look at the federal requirements, right? Because you would hate to submit a bid and, it's only for an 8A program and you are not an 8A program, right? You want to make sure that you're meeting the requirements of the bid. So if it does require a state level certification, you want to make sure that you have that. So we can talk more offline too about how we game plan, because that's a very specific question and it usually requires me digging into those specific states to find some of that overlap and reciprocity. So thanks for the question, and we'll chat offline. So as we're talking about private sector programs, again,
Sorry.
No, you're okay. I don't need the slides, it's all good. No requirement to meet the small business status. And this is another advantage for folks that may be outside of that small business, that small business status, either on the economic or the number of employees side. They do allow for fast track reciprocity of application. So if I applied as a woman-owned business under WeBank, also being a veteran, I could turn to Novova or the NMSDC and submit my certification. And because I have a WeBank certification, that would fast track and cut down on the amount of certification time in each of those entities. They also allow for opportunities for advanced bidding prospects, funding opportunities, business matchmaking. I do want to make a point. So there is only one certification as of right now for LGBT members, LGBT-run businesses, and that is with the National LGBT Chamber of Commerce. The state of New Jersey just put in place an executive order, and they're working through codifying it right now. And LGBT, I think it's LGBTQ. I apologize if I get that incorrect. Certification program on the state level. Normally, if states have this certification, they run it through NGLCC, but we may see states also certifying our LGBT run businesses as well. So some of the things that we like to talk to our small businesses about is choosing wisely, right? It's based on your target contracts. Because you can hold multiple certifications, this is time consuming, submitting all of the paperwork and making sure you have all the documentation together. So choosing wisely and having a strategy is important. Wasting your time or worse, your money on certifications that you don't need at this particular point, that's a waste for you. Federal contracts require federal programs. There's very rarely any leeway, and I don't think I've ever seen any leeway where federal government said, yeah, sure, we'll accept the state of Ohio. However, state and private sector opportunities may allow for a combination of programs. So it's great to always ask if you are working on a state or private sector opportunity. If you are a certified company with the federal government, to ask if that's okay. Usually they will provide that as part of the bid. They will say what certifications are acceptable for that particular bid. But if you don't see it, again, does not hurt to ask. Choosing wisely, we talked about this earlier. Certain certifications have limits. So the 8A program is 9 years. Your small business status, this is one that as you grow, you will most likely grow out of. And again, 30 days is a good benchmark as soon as you grow out of that. And Andres, we had this issue with a client that had a tax issue where, they knew as soon as they filed their taxes, they were going to be outside of this. And we talked about that and we said 30 days. As soon as you file your taxes, that's when you definitively are going to be outside of that threshold for receipts. So you have 30 days from filing your taxes to make sure that you report that. This was a woman-owned program, said, make sure you report that, because again, you're going to run into a lot of issues with a bid protest should somebody find out that you're no longer a small business. And economic disadvantage. Again, as soon as you file your taxes, because that's usually when you no longer meet that economic disadvantage. You want to make sure that you are reporting that. Again, that 30-day limit is on the federal level. That is also a great limit to understand on the state and private sector. Recertification on the state and private sector certifications are usually 1 year. So it's a lot harder to hide when you are outside of those certification limits and eligibility requirements for those particular programs. Now we're going to dive into some common issues with certification programs, and then I'll turn it back over to Andres to talk about back on the contracting side, some other issues that contractors have. Failure to maintain that ownership and control. And we've talked about this a little bit. Adding non-eligible investors. I have this conversation with a lot of our startup companies that, they are in high growth mode. So they are constantly bringing on investors every 12 to 18 months. And those investors may be diluting their equity, but they're definitely diluting their control, because that is what investors and startups are really looking for. They're looking for that control in addition to that equity. So adding non-eligible investors, changes in not just the board, but in the powers of those particular board members, and those changes in decision-making authority. The next is outgrowing that small business status or that economic disadvantage. And again, the issues arise not because you're not eligible, but because you haven't reported it. And that may cause, that failure to report that change in status may cause issues for you down the road. And then affiliation. So Andreas mentioned this earlier, that failure to operate independently from a non-eligible business. Now, this may arise in a couple different ways. This may be that non-eligible business exerting control over the eligible business. So in a joint venture setting where there are certain requirements for the eligible business, certified business, to be in control of certain things, if that non-eligible business is exerting that particular control, that may break that certification, and there may be some affiliation happening. Or the origin of the business, how the business actually begins. The first time I ever encountered this was a sort of a construction business, a minority-owned construction business owned by the father. He decided he was going to shut down a couple of his subsidiary businesses. Instead, his son said, hey, I will take the business, one of these subsidiaries, and I'll take it and I'll run it separate from you. So it was no longer a subsidiary of that particular construction company. Unfortunately, because he was running that business, his primary customer was his dad's company. So the DOT had a big issue with affiliation because the primary customer was the dad's company. There was no gifting, there was no sale or transition of the business. So it seemed like there was some affiliation happening where, the dad just gave the son the business and was helping him run it. And of course, this was a multi-million-dollar construction company and a brand new smaller subsidiary that was happening. So there were a lot of affiliation issues that we then had to work through. And ultimately, the answer to that was you need different customers. Maybe waiting on this particular certification is the best for you until you've built up enough of a customer base that you're no longer, primarily working with your father's business. Not the answer that particular person wanted to hear, but there wasn't any way to be able to avoid that affiliation for that particular DOT certification. All right, turning it back over to Andreas to talk about some more compliance issues for new contractors.
Yeah, thanks. So this is going to be a little bit quick because I want to make sure that we're respectful of time and leave some time for Q&A at the end. But yes, this is going to deal with sort of the most common compliance issues for new contractors. Before I get too far into it, I will say this: we often get the question of, hey, we're now a government subcontractor, or we're now about to bid on a prime contract. What do I need to comply with? What are the things that I need to do? That is a very complicated and nuanced question that's going to depend on 1,000 different variables, and is something that I could spend probably years training the company on if they wanted to be in 100% compliance with everything. This is incredibly complex stuff, and there's a lot of compliance obligations for government contractors. So keep in mind, this is very high level, and even the most sophisticated contractors run into issues decades into their operations. So keep that in mind. But where these compliance matters largely come from is the FAR, and FAR Part 52.2 provides the full text of the clauses that are commonly included in federal government contracts. Now, a really unique aspect of government contracting at the federal level is something called the Christian Doctrine. This comes from a decades-old case that basically stands for the position that a mandatory FAR clause that expresses a significant or deeply ingrained public procurement policy is imputed into the contract. It's read into the contract even if the government screws up and leaves it out of the contract itself. So this is super, super important for prime contractors because there may be additional compliance obligations that are not apparent on the face of the contract that are nevertheless incorporated into the contract. So we do see this issue come up quite a bit. Now, as to subcontractors, the Christian Doctrine actually doesn't apply, though there's been some movement in this area on certain public policy FAR clauses, particularly in the labor operations, right? Affirmative action, labor standards, equal opportunity, those clauses can be read into a subcontract even if they don't appear on the face. But everything else, if the prime contractor does not flow that contract clause down to the subcontract, then the subcontractor has no compliance obligation with it. The prime may still have an obligation to ensure its subcontractors comply with that clause, but the subcontractor doesn't have any direct obligation. And as we discussed before, this lack of privity, the government doesn't have an ability largely to go after the subcontractor for non-compliance. They can only go after the prime contractor, and the prime contractor may have an ability to go after the subcontractor, but not if they fail to flow it down. Next slide. Okay, so very common issue that arises is certifications and representations. More so than any commercial contract, government contractors are subject to a huge amount of certifications and representations. And this is not only through the contracts themselves, but also just through the act of being a government contractor. To be a government contractor and qualify for these contracts, the subcontracts, you have to be registered within the database that the government maintains of all contractors, which is called the System for Award Management. And within that System for Award Management profile, contractors actually have to execute a huge number of certifications and representations about the company. Largely, these are the sort of compliance issues that we're going to be talking about quite a bit, but those are all required as part of just being eligible to be a contractor, and that's in addition to the certifications and representations in the prime contract. And another unique aspect of this is that these are often implied. In fact, this has been somewhat challenged a little bit of late, but there's a unique concept in federal contracting which provides that the very submission of an invoice or request for payment from the government comes with an implied certification of compliance with everything in the contract and every applicable federal procurement law or regulation. So that's hugely important. Effectively, just by saying, I need to be paid, you're saying I'm in compliance with everything. And what ends up being important about that is if it turns out that one of your certifications representations is not true, and especially if you knew that it wasn't true, that can serve as the basis for effectively saying that every single payment made after that initial invoice where you knew it wasn't true was essentially a fraudulent request for payment. And so you might have False Claims Act liability just from every single one of those invoices. And under the False Claims Act, that's very serious because the False Claims Act provides for treble damages, so 3 times the amount the government paid to the contractor after the fraudulent activity. So every one of those invoices times 3 is the damages. So this is very serious stuff. So moving to organizational conflicts of interest. What this represents is basically a circumstance where either the contractor has some sort of unfair competitive advantage as to other contractors competing for the same contract, or if they're in a position where they're unable to provide impartial assistance to the government under their contract. So this can come about in a number of ways. It can be anything from a contractor gaining unfair access to information that gives them a competitive advantage that other competitors don't have access to. It could be from things like a former government employee coming to work for the contractor, giving them an advantage in that respect, or circumstances where the very performance of a contract creates sort of a conflict as to another contract. So for example, if a contractor is helping an agency develop its acquisition planning processes, develop the solicitation for a contract opportunity, if they're drafting the scope of work or the evaluation criteria, they might have a competitive advantage, so the government does not want them to be able to compete for that contract given that advantage. So the good thing about OCIs is that they don't necessarily mean that a contractor is ineligible to compete for a contract or that their current contract needs to be terminated. These can often be mitigated. And what a contractor will do is submit an OCI mitigation plan to the government, which will do things like, say, firewall off the individual employees that have access to that competitive information, make sure that they're not a part of the process for submitting a bid for the affected competitive contract, that sort of thing. So OCI mitigation plans can take a number of forms, but they can be utilized to avoid those issues, at least enough to satisfy the government. Another unique issue is strict notice requirements. Jasmine referenced the 30-day notice requirement for when you're no longer eligible for a program. Those often follow changes of ownership. The notice requirements are very strictly enforced and can have serious consequences. So another strict notice requirement comes along with when the government changes the contract, or the government does something that delays the project. Those sorts of things happen quite a bit, and the contract usually has rights to assert additional time or money as part of their performance. But in order to avoid a situation where they effectively give up that right, they have to provide notice to the government. It has to be quick. So often it's a 30 days within the change that happens by the government's orders or by changed circumstances. If the contractor doesn't assert a right within those 30 days, they may actually waive that right entirely and not be able to recover anything at all. So it's very important to make sure that those notices are provided timely. Other notice requirements that come up quite a bit, and there are a large number of them that we couldn't cover here, but cybersecurity incident reporting is one that I always reference because the timelines are very, very tight. Currently, if a contractor suspects that there was a cybersecurity incident and it affected some portion of the government contract performance, or maybe even potentially exposed government information, The incident actually needs to be reported to the government within 72 hours of finding that. So very little time to investigate and come to a determination. So often we say to clients, report it even if you're not absolutely sure that anything was accessed, because that's ultimately you want to just make sure that you don't report it too late, because that's worse than going back and saying we figured out that not that big of a deal. And that timeline is being moved up increasingly. The government is doing more and more to look at cybersecurity of contractors. And a proposed rule that came out in October of last year, proposed moving that 72-hour notice requirement up to just 8 hours. And some agencies have even quicker than that. The Department of Homeland Security, they have a requirement to report cybersecurity incidents within 2 hours. So very, very tight timelines here. Finally, a really unique issue here is the release and waiver of claims. We see this issue a ton. The government has a unique ability to enforce releases and waivers of any claims, and they definitely make use of it. So in addition to the sort of waivers that come from not reporting or providing notice within enough time, the government will often include release and waiver language in even administrative things that they do. So say they're just exercising an option to say we want to exercise the right to extend the performance for another year. What they will often do is they'll include in a modification language that says the contractor is releasing the government from anything and everything under the sun that may have happened in connection with this contract that occurred before this modification is signed. If the contractor signs it, that's exactly what happens. So even if they had a claim pending against the government and they have an ability to otherwise go after the government for additional costs or anything like that, if they sign that waiver and release, they are not going to be able to pursue it. So we always say to contractors, read those modifications very, very, very carefully. And if you see anything like language that would release or waive any claims or anything like that, you tell the government, I'm not going to sign this until you get rid of that language. And if the government says, well, too bad, you have to do it, then you just simply refuse. And if the government issues a unilateral modification that has that release and waiver language in it, then the contractor is usually able to continue to pursue that claim despite that language, as long as they're very clear to the government, we don't agree with this language. Next slide.
I had a question on the OCI mitigation.
Sure.
What do you typically advise your client then? Do you advise them to be proactive, and if you suspect you have an OCI, you submit a mitigation plan on your own? Or do you basically advise them to wait for the government to make the determination that there's an OCI and that they need to submit a mitigation plan?
Yeah, that's a great question. We usually do say, especially at the outset, when we're talking about an OCI that impacts a competitive acquisition that the client is pursuing, we're going to say be proactive about it, because the OCIs actually can be a protest ground. So a disappointed offeror can say, we think the awardee has an OCI and shouldn't have been considered for this. And if they're right, then that award can be taken back by the government. So we generally advise in that situation, be proactive, say to the government, we think we do have an OCI, but we think it's one that can be mitigated through this plan. And you submit that OCI mitigation plan through along with the proposal. Now, when the government sort of knows that there's a potential for an OCI as part of the proposal submission process, they'll actually put stuff in the solicitation to provide for, if you want to submit an OCI mitigation plan, here's how you do it, here's what it has to be included and all that sort of stuff. So yes, in that circumstance, we do say be proactive. But if an OCI comes up in the middle of performance, sometimes we say take a beat to sort of see, is this really an OCI? Is this really going to be a problem? And develop the plan based on that. The good thing is once you're in the middle of performance, you can have a little bit more of an open dialogue with the contracting officer to work out those sorts of issues. So it'll definitely depend a little bit on the circumstances, but as with most things, it's usually better to be proactive. Okay, so moving on to additional compliance requirements. So the FAR has a lot of stuff that governs workforce. As I mentioned before, right, the FAR is often used as a place to sort of test out, you know, sort of regulatory mechanisms that the government sort of wishes they could do in the private sector. So we see that a lot with workforce stuff. So there is a few statutes that govern the federal contractor workforce, including the Service Contract Act, the Davis-Bacon Act, which covers construction contracts, and then there's a whole rash of Department of Labor regulations that deal with things like minimum wage and benefits for employees that are working under a government contract. So this you know can do stuff like incorporate a wage determination. The Department of Labor will examine where contract performance is going to be taking place, what the wages look like for similar work in that area, and then they'll issue a wage determination that goes into the contract, and the contractors have to pay their employees no less than those amounts. It'll also provide for benefits like leave, and other sorts of healthcare and other fringe benefits that all need to be complied with. Affirmative action and EEO is something that is a huge burden on some companies that is very much unexpected when they enter the federal market space, especially if they are a sophisticated company that has worked in the commercial space for a long time and are dipping their toe in the federal space. In addition to the sort of typical, you can't discriminate in hiring decisions and in employment actions and that sort of stuff, there actually is often a requirement for affirmative action plans for every major location of the company to ensure that there are plans and ways to set goals and measure against those goals in terms of hiring for for people of different races, nationalities, for different social classes, potentially for the disabled, for veterans. Those sorts of things, are often a big headache for a company that's entering this space after having operated in the commercial space for a long time. There's also some unique aspects in government contracting, especially for staffing contracts, where a contractor is largely just sort of putting people in positions that work in government offices. Myself, before law school, I was one of these contracts. I was an administrative assistant to a bureaucrat within an agency. I was under a contract where I was reporting to a government office every day, reporting to a government employee, but I was technically hired by a contractor. And what happened at the end of my contract, or my company's contract, I should say, they did not win the follow-on contract, and so I thought I was out of a job. Well, it turns out that there was a clause that was in place at the time, and sort of comes and goes depending on who's in the White House, but this non-displacement of qualified workers. What this clause requires is that a follow-on contractor to a personal services contract like that has to actually make offers to the qualified workers that are working on the incumbent contract, so that they can move over and there can be continuity of operations without disrupting the work. So that's exactly what happened with me. I was moving from one contractor to another. My day-to-day didn't change, but my employer was changing. So that's certainly a unique aspect there. Another unique aspect, and this is increasingly happening, is the FAR actually places some restrictions on certain confidentiality obligations on employees. Usually this is really tied to making sure that there's no obligation of confidentiality that would get in the way of a government investigation. So it's usually there needs to be carve-outs of any NDAs or confidentiality obligations to work with the government on any investigations. And then there's more recently, there are restrictions on mandatory arbitration provisions in employment agreements. Right now, they're just focused on employers that are government contractors cannot make mandatory arbitration to resolve employment discrimination claims and claims by employees related to sexual misconduct or sexual harassment by an employer. Next slide, please. Okay, I touched on IT issues earlier, and certainly those are front and center. But let's start with the sort of security issues, right? So security clearances is something that's unique in government contracting, and it is something that has to be paid very close attention to. Often contracts are restricted to companies and personnel that hold a specific level of security clearance. Usually this is when they're being, they're gaining access to sensitive government materials, classified materials, etc. Maintaining security clearances is a hugely important aspect of government contracting, especially if you do work with the Department of Defense, NSA, FBI, CIA, etc. In terms of IT systems, that really could be its own presentation in itself. This is an area that is developing very quickly. Largely, contractors are required to comply with the National Institute of Standards and Technologies cybersecurity standards, NIST. That's the sort of baseline sort of certification, or I'm sorry, the baseline compliance requirements. But what is moving in the direction, especially in the Department of Defense, is the CMMC, the Cybersecurity Maturity Model Certification Program. What the Department of Defense is doing is they're saying that companies need to meet a specific level of cybersecurity maturity in order to be awarded contracts. Now, this is still in its infancy, it's still developing, but where it's heading is that there's going to be, right now, it's 3 levels of cybersecurity maturity that a contractor has to meet in order to be awarded a contract. And so companies are going to have to go out and get certified at one of those levels in order to qualify for certain DoD contracts. And it's starting with the Department of Defense, but it is certainly going to come to civilian agencies eventually. And then there are prohibitions on certain technologies. Largely, these are going to be Russian and Chinese-owned technology firms that may be providing those governments with access to important government information. So a few of the companies are listed there, but the most recent one that's come up is ByteDance, which is the company that owns TikTok. TikTok cannot be used on any phones or platforms that a government contractor is using for performance of that government contract. So this has spawned a lot of companies having to produce policies on use of TikTok. Next slide. So a lot to take in here, but what we're talking about is some of the really procurement fraud sorts of high level sorts of compliance issues. So once contracts reach a certain size, contractors actually have to have a written code of business ethics and conduct, and this is there not only to sort of do the typical sort of ethics standards that a company might do on its own, but also needs to include rigorous identification and self-reporting mechanisms to identify wrongful conduct that may come up as part of a government contract, and also has to have things like anti-retaliation language to protect employees who might be working with government investigators, that sort of thing. In terms of anti-kickback and gratuity, this is really looking at limiting any sort of payments or in-kind sort of payments to any government employee who's involved in any of the contracts. This comes up more often than you'd think, but yeah, there has to be standards that govern the contractor to make sure that there aren't any kickback schemes and that sort of thing happening. Next is cost and pricing compliance and the Truth in Negotiations Act. So unlike in many other areas, the government is very strict about cost accounting, especially when we're talking about those cost contracts that I mentioned before, where the government is paying for all costs that are allowable, right? Allowable is the key issue there, and also allocable, which means can it be charged to the contract? Is this something that falls within the scope of the contract? Can it be charged to the government rightfully? Again, this is really in-depth stuff, and what I generally recommend to clients is that as soon as you get to a point where you start running into cost compliance obligations, you really need to get an experienced accountant that knows what they're doing in the government contract space, because this is a unique area. The Truth in Negotiations Act is basically comes down to in negotiated procurements, the contractor is essentially certifying that the information that they're providing to the government about how much it costs them to perform and that sort of thing is actually truthful, right? So the Truth in Negotiations Act, or TINA, operates to basically say that if the contractor's certification as to their costs are incorrect, the contract price can often automatically be adjusted downward, or there can be more serious consequences, such as under the False Claims Act. And then to the sort of State Department, commerce and trade sort of regulations that run into here, country of origin requirements and restrictions on foreign purchases. So country of origin requirements, this flows from the Buy American Act and the Trade Agreements Act. The government obviously favors manufacturing that happens in the United States. They want to cut down on the reliance on, say, China for supply chains for the government. So there are strict requirements in manufacturing and goods contracts about where the materials and the goods are being sourced from. And then there are specific restrictions on foreign purchases. Largely these follow sanctions that the State Department has issued against individuals, companies, countries. And then there are particular countrywide restrictions. So there are actually, there's a prohibition on most transaction involving certain countries. Currently on that list is Cuba, Iran, Sudan, Myanmar, and North Korea. But also there is an ability for the government to say any state sponsor of terrorism, which can be a moving target in some respects. So that largely wraps it up. But of course, we wanted to leave time for Q&A. So please, I know we only have about 5 or 6 minutes, but if anybody has any questions, feel free to say them in the room or enter them in the chat.
Any questions? Sure.
This is a particular one about the reps and certs we were talking about. In a proposal, you see them asking for you to include them in the proposal, and they have the regular reps and certs and the alternate reps and certs, and then fill them out in SAM. And is there any particular difference between the annual reps and certs, the 52-204-8, and the alternate, the 252-204-7007? And are you usually including them both if they're in there? Because I can never figure that out.
Well, I would love to give you a very easy answer there, but unfortunately, it'll sort of depend on the circumstance, and it really does come down to which one is applicable not only to the contract, but the specific situation where that representation or certification becomes relevant, right? So what I generally counsel clients with is be prepared to be in compliance with both. And if there's a conflict where you've got compliance with one and, perhaps, you comply with the overarching annual, SAM standard representations and certifications, but maybe not the alternate, then it becomes a sort of question of, can we find a way to say that the alternate doesn't apply here, right? So it's unfortunately going to be a nuanced, sort of fact-specific analysis there. But yeah, it's generally see what you can do to comply with the more stringent standard if there's two sets, whether the alternate or the underlying one with SAM, which usually the alternate is going to be the more stringent standard.
Thank you.
Okay, any other questions? Nothing popping up in the chat. I am going to read the CLE codes for those who are attending virtually. The CLE codes are TH3202. That is TH3202. And the second one is TH3915. TH3915. Thank you all for attending. We are going to have our second workshop, which is going to focus on navigating litigation and government investigations. That's going to be here on June 18th. That's also going to be a hybrid program. So please be on the lookout for that. We will be sending you invitations and promotional materials for that starting very soon. We are also going to send out a link to the video recording of this presentation within 2 business days. So please monitor your emails for that. If there's no other questions, then I think we can close this. And again, thank you all for attending and participating in the workshop.
And don't forget to submit your surveys, and for those in person, sign the time.
So those two codes are just for the